Good morning and welcome to Mayor Brown's webinar on the Supreme Court's recent ruling on the Clean Power Plan, West Virginia versus EPA. And this was an exciting end of term for anyone interested in administrative law. After years of buildup by the Supreme Court and pressing by advocates, we got a fully fledged ruling on a new doctrine of administrative law and a name for it, the Major Questions Doctrine. And there is a lot in the West Virginia decision. We have the Major Questions Doctrine named, categorized, and applied to the particular set of facts before the court, the legality of the Clean Power Plan. Have a pretty full description from the court of what this new doctrine is and how it's to be applied. I think we can also draw some lessons from the court's opinion about other doctrines of administrative law, the Chevron doctrine in particular, and about constitutional principles like non-delegation doctrine and separation of powers. And in the short period since the decision came down, we also have a lot of speculation about what it's going to mean in other areas of administrative law for other regulatory schemes. And we're going to touch on all of that today. There's a lot there. My name's Tim Bishop. I'm a partner in the Chicago office of spent my career litigating to try to keep regulatory agencies within the scope of their statutory authority. And I'm joined by Avi Kupfer, my colleague in Chicago, who came to us from the Environmental and Natural Resources Division of the Department of Justice. So he has seen the other side of the coin, defending government regulations from attack. So between us, hopefully we can provide some insights into the court's new ruling. And just a few housekeeping matters to start. If you're accessing this webinar through Citrix and you're having problems, we suggest finding a different way. Citrix isn't always stable here. Hopefully you're all seeing us well. Now, if you have any questions during the webinar, there is a question and answer feature at the bottom of your screen where you can type in your questions. We can try to address those as we go along if they fit in. Otherwise, we'll do a Q&A session at the end of the program. So why don't we begin? Avi, why don't you launch into the CPP and the court's decision?
Yeah. So just a very brief overview of what we're going to cover. We'll start with the history of this case, which is pretty interesting in and of itself. But the real meat of the CLE is going to be discussing this newly cemented doctrine of administrative law, its application in this case, and its consequences going forward, of which there will likely be many. So just a very top level overview, West Virginia versus EPA was this challenge to President Obama's signature environmental initiative to reduce greenhouse gas emissions. And EPA employed the idea of generation shifting at the grid level, which is the idea that it could shift electricity production from higher emitting to lower emitting producers, moving producers to cleaner sources of energy. And the challenge to that regulation started the minute it was released during the latter part of the Obama administration, and it went all the way until 2022, when the court issued its decision just a few weeks ago in West Virginia versus EPA. Now, there were two holdings in that decision. The first holding was about standing, constitutional standing, which is the requirement for plaintiffs for there to be a case or controversy in order for a court to rule in a case. And we're not going to be spending much time on that holding. The court held that the case was justiciable, that it could issue a substantive ruling because the DC Circuit overturned the Trump administration's repeal of the Clean Power Plan. And even though the Biden administration said it would not enforce the Clean Power Plan going forward and would issue a new rule, the court said nonetheless the case was justiciable. But the key point here is that jurisdiction was not obvious at all, and there were off-ramps for this court, and a more modest court may have taken some of those off-ramps. But what we're going to focus on this morning is not the standing holding. It is the statutory interpretation holding and this full-throated embrace of the major questions doctrine. So let me just go back here. So, very, very briefly, the EPA relied on the Clean Air Act to issue the Clean Power Plan. And there are three main programs under the Clean Air Act for controlling air pollution from stationary sources. The two main programs are the National Ambient Air Quality Standards for air pollution that could endanger public health, like carbon monoxide, and states submit plans for implementing those standards. The second one is the Hazardous Air Pollution Program, which is where EPA directly regulates air pollutants that aren't covered by the National Ambient Air Quality Standards. An example of this one is benzene in gasoline. This Clean Power Plan relied on the third bucket of programs that the EPA uses to control air pollution from stationary sources, known as Section 111. And that allows the EPA to set performance standards for specific categories of stationary sources. So rather than regulating the air pollutant, it's regulating the source. And the way that EPA does that under Section 111 is by deciding an amount of pollution reduction to be achieved from a given source. And the key language that it relied on to do the Clean Power Plan is this language in Section 111, which was the focus of the court's decision. And that language allowed EPA to set emission limits by determining the level of pollution reduction achievable by using the best system of emission reduction. And EPA, the Obama administration, EPA looked at that language and decided that the best system of emission reduction for existing power plants was essentially shifting generation from higher emitting to lower emitting sources of electricity. So from coal to natural gas, wind, solar, etc. So so we covered most of this on the previous slide, but I think a key point here, and the dissent sort of pointed this out in the decision, is that EPA determined that this best system of emission reduction would reduce national electricity generation from coal-fired power plants from 38% in 2014 to 27% in 2030. It's already more than achieved that reduction, largely because of shifts to natural gas. And currently, the most recent statistics from the Department of Energy have electricity generation from coal production standing at 22% nationally. So this was a fact that the dissent ends up relying on. But I guess the key point is that EPA realized that by implementing this best system of emission reduction, it would cause coal plants to close. They acknowledged it would eliminate jobs, have a major financial impact on industry, and it was a more aggressive form of energy transformation than the EPA had ever tried to do through Section 111. So the day that the Clean Power Plan was released, 20 some odd states sued the EPA, and the Clean Power Plan never actually went into effect. The states filed a lawsuit in the DC Circuit. The DC Circuit denied a motion for a stay. They went to the Supreme Court, and the Supreme Court granted that in 2016. So litigation then continued in the DC Circuit, but the DC Circuit never issued a merits decision on whether the Obama administration could enact the Clean Power Plan, because before it could do that, in 2019, the Trump administration EPA issued a repeal of the Clean Power Plan, basically saying that it did not have the authority under Section 111 to do generation shifting. And it also released a new rule, the ACE rule, the Affordable Clean Energy Rule, which instead of reducing emissions from coal-fired power plants by requiring generation shifting, it required sort of more typically what EPA requires when it regulates emissions from stationary sources. These are known as inside the fence techniques. And they're things like equipment upgrades and requiring changes in operating practices to improve efficiency. So that rule was challenged, and the repeal was challenged again in the DC Circuit. And a set of states, including West Virginia, intervened to defend the ACE rule and to defend the Trump administration's repeal of the Clean Power Plan. And the DC Circuit ended up holding that the Trump administration's justification for repealing the Clean Power Plan was deficient under the Administrative Procedure Act. And initially, it vacated the Clean Power Plan and remanded to EPA. And the vacatur essentially meant that the Clean Power Plan could go back into effect. But it did that in January 2021. So by February 2021, the Biden administration EPA came in and asked the DC Circuit to stay its vacatur so that the Clean Power Plan would not be in effect. And the reason it gave was that it was considering issuing an entirely new rule to regulate emissions from stationary sources, largely because the goals of the Clean Power Plan in terms of coal, shift away from coal had already been met. And the DC Circuit accepted that reasoning. No one opposed it. It stayed the decision. So the Clean Power Plan never goes into effect. But the Supreme Court, as I had mentioned at the start of the presentation, still decided to take up the case. And the main question in the case was whether this language in Section 11 on best system of emission reduction authorizes EPA to do the sort of generation shifting that it did in the Clean Power Plan. And what the court held was that Section 111 does not authorize EPA to reduce emissions through generation shifting, which on its face looks like a pretty straightforward statutory interpretation case. But the new administrative law move that the court made in this case was that it acknowledged that Section 111 had some ambiguity. And in previous cases, what you would expect the court to do in that scenario is then to go into the Chevron deference framework, which is the idea that if a statute is ambiguous, if the court decides a statute is ambiguous, it looks to the interpretation of that statute given by the agency that is responsible for carrying out that statute, and it decides if that explanation is reasonable. Instead of doing that, the court employed the major questions doctrine, and this was the first formal recognition and most developed explanation of the major questions doctrine. There are cases that Tim is going to discuss going back to the early 2000s where the major question doctrine was alluded to, but this really crystallized it. And going forward, it's going to be a central part of any statutory interpretation analysis when it comes to administrative law. So there are essentially two steps that Chief Justice Robert articulated in the major questions doctrine. The first step is whether this is an extraordinary case. And the chief says that a case is an extraordinary case based off of the history and breadth of the authority that is being asserted by the agency and the economic and political significance of the authority being asserted. You look at those two things, and if they are significant, then the court should pause before concluding that Congress meant to confer the authority that the agency is claiming. So that's the first part, whether the case is an extraordinary case. If the case is an extraordinary case, the opinion says, well, then you need to ask if there has been a clear congressional authorization for the power that the agency is claiming. So it essentially has this two-part framework. And the court applied the major questions doctrine to Section 111 and the authority asserted by EPA to issue the Clean Power Plan. And it essentially found that Section 111 was intended to be a gap-filling measure. You have these two major programs, the National Ambient Air Quality Standards and the HAP program for regulating airborne pollutants. And Section 111 had never been used by the EPA to do what it was trying to do here, to take on this enormous regulatory authority to shift national energy generation from some sources to other sources. And it looked at several facts. It looked at the fact that EPA had previously interpreted Section 111 more narrowly to only require emission reduction, the best systems language. It had only used that to require emissions reductions to individual sources. It looked at the fact that Congress had rejected legislation that would have enacted some of the things that EPA did through the Clean Power Plan, like giving states the option to require cap and trade schemes for power plants. And EPA even had admitted that it was changing its view of its authority under Section 111. So looking at all of those facts, the court found that the major question doctrine applied because EPA was an extraordinary case, and that there was no clear congressional authorization of the type that EPA was claiming to require generation shifting from coal-fired power plants to other energy sources. And now I'll turn it over to Tim, who's going to talk about some of the other applications of the major questions doctrine that the court discussed.
Thanks, Avi. Let me just start by emphasizing what Avi said about the move that the court made in this case. The court agreed with the government that there was a colorable textual basis in Section 111 for the generation shifting regulation. Colorable textual basis. And that means, I think, that that under traditional methods of reviewing administrative action, that you would then ask, well, was the interpretation that the agency came up with of the text, was it reasonable? In other words, the generation shifting was not ruled out by the text of the statute, and then the question would be, was the interpretation a reasonable one? And in determining that, the court would look at the context, the statutory history, the regulatory history, all the sort of traditional tools of statutory interpretation, and ask whether the agency had done a decent job in reaching a conclusion. And if it had, then the regulation would be upheld. There would be deference. That was the SG's argument, that there was no preclusion in the text of the Clean Air Act for this rule. And when you looked at the regulatory and statutory history and context, that it was a reasonable interpretation. Although the government did not cite Chevron in its brief, and didn't argue for deference. It used these other traditional tools that fit under Chevron, but didn't ask for Chevron deference. So the court didn't go that route. It adopted this new end run, if you like, around those traditional textual and historical analyses. If the agency has claimed for itself extraordinary or radical authority, then you don't have to consider those other more traditional ways of statutory interpretation. Instead, you apply what now has a name in the major questions doctrine. Now, this is the first time the court has used that phrase, major questions doctrine, but there certainly are antecedents to this approach to reviewing administrative action. Quite a lot of them. I think not until earlier this term, did they coalesce. And as Justice Kagan's dissent points out in West Virginia, all of these earlier cases had other things going on. I mean, they had either reference to Chevron or to more traditional modes of interpretation. But at bottom, I think when you look at them, you can see in them the antecedents of the major questions doctrine. And I'll just give a few examples here because they, these cases strike down regulatory action that I think now would be struck down under this new rubric. So in UARG, the Utility Air Regulatory Group case in 2014, the court squarely adopted a clear statement rule. If the agency is going to make a decision with vast economic and political significance, then Congress has to clearly say that that's what it's intended. And in UARG, you may remember, this was the agency, EPA, claimed to bring within Title V and the PSD prevention of significant deterioration programs, greenhouse gases from stationary sources, and then realizing that greenhouse gases were emitted by all sorts of small emitters, homes, for example. Your home is an emitter of greenhouse gases. It came up with a fairly arbitrary limitation on the application of this permitting requirement based on the number of tons of greenhouse gas emission during the year. So first of all, it invented this new greenhouse gas basis for stationary source regulation, and then because that went too far, it applied an arbitrary limitation in the tailoring rule. And the court said neither of those moves was permissible. And the first one, marked a huge expansion of the stationary sources covered by the CAA. Millions and millions of new sources would be covered by Title V, and only the EPA only saved that from happening by this backup tailoring rule. So in that first move, the court found that was a vast expansion of agency authority, and Congress had not clearly permitted it. Another case that the court cites that looks in the same direction is Brown against Williamson, where the FDA, which has authority to regulate drugs and devices, tried to regulate tobacco products, which does not look like a drug or a device, at least as traditionally understood. And so Congress could not have intended to delegate such sweeping and consequential authority in so cryptic a fashion as by using the words drugs and devices. And one way to think about the question, the baseline question of how radical is the authority here and has Congress delegated it, is Justice Scalia's phrase from the Whitman case. Congress does not hide elephants in mouse holes, probably one of the most quoted phrases from any Supreme Court opinion, but a good way of thinking about the issue. Can we move on to the next slide? Now, and those aren't the only predecessors. There are plenty more, although, as the dissent says, they all have other things going on. But this term, the court finally got serious about the major questions doctrine, and twice earlier in the term, in per curiam opinions, it essentially used the doctrine without naming it, without calling it that. And again, these illustrate the kinds of situations where the doctrine is going to apply. So the CDC, you may remember, decided that in the context of COVID, that people should not be evicted. That that evictions, mass evictions during a time of economic dislocation would likely spread COVID further than if people were able to remain in their homes. And so the CDC adopted a national eviction moratorium, saying that it was necessary to prevent the spread of disease. The court struck that down in Alabama Association of Realtors because of its sheer scope and unprecedented nature, and because it really doesn't look like anything that CDC has ever done before, or that anyone has thought that CDC might be able to do. It's just not within the traditional bailiwick of the CDC to issue nationwide rules about evictions. Similarly, in the NFIB case, OSHA, which regulates workplace safety hazards, required working Americans to either obtain the COVID-19 vaccine or to undergo weekly medical testing at their own expense. So, their own expense. So it's an effort, not only to determine who has COVID in the workplace, but also to shift people towards getting vaccines because they're going to have to pay for these weekly tests. So a broad public health measure designed to contain COVID-19, not the traditional sort of workplace safety hazard that OSHA is concerned about. And the court held that sort of broad public health measure just was not within OSHA's statutory authority. And so, in a phrase from the UARG opinion, the court, I think we can sum up where they are. We typically greet assertions of extravagant statutory power over the national economy, which both the CDC and the OSHA regulations were, with skepticism. So this was a 6-3 opinion written by the Chief Justice. The Chief Justice is, I think we all know, is a little bit more restrained in his approach generally than some of the other conservative justices on the court. We call him an incrementalist. He doesn't like to go further than is necessary to decide the particular case before him. He doesn't like to lay out laundry lists of rules to sort of supplement what he's said in citing the case. Justice Gorsuch, joined by Justice Alito here, wrote a concurrence that I think is very helpful in thinking about how the major questions doctrine may apply beyond the facts of the CPP. The triggers that he listed three triggers, and I should say that I think I don't have much doubt that the Justices Barrett, Kavanaugh, and Thomas probably agree with the Gorsuch approach. I think that there was some politics involved here in supporting the Chief Justice, and not turning this into a messier decision than it needed to be. But I think that we can count on Justice's Gorsuch opinion as being pretty good statement of where the majority of the court currently are. So in applying the rule, first of all, is the agency claiming power to resolve matters of great political significance or earnest and profound debate across the country? And so I think the takeaway from that is the Chief talked about economic significance principally, but Justice Gorsuch is concerned too that we have a country that's divided in many ways on its views on many matters. There is no doubt earnest and profound debate in the country on many matters, not just involving environmental regulation, but a host of other issues. And Justice Gorsuch is concerned that it is not the job of an agency to shut down that debate by taking a particular position. So on the big issues of the day, in essence, it's not the job of executive agencies. It's the job of Congress to make decisions. Second, Justice Gorsuch furthers the majority's view that if the agency is purporting to regulate a significant portion of the American economy, require a huge amount of spending by private entities, that's another trigger of the major questions doctrine. And the third one is the agency intruding on areas that are traditionally matters of state law. Zoning, for example. Zoning is an issue traditionally for states and localities. And land use, more generally. So under the Clean Water Act, for example, which I'll come back to when we talk about consequences of this decision. Under the Clean Water Act, Congress recognized and the court has recognized that traditionally states have authority over land and water use. If the EPA and the Corps of Engineers adopt a definition of waters of the United States regulated by the permit programs of the Clean Water Act, does that intrude into these traditional areas of state control? I think the answer is yes, and the court's going to have a chance to address that on the first day of the new term in the Sackett case, and we'll come back to that. You move on, Abby. So those are the triggers for applying the new doctrine, and then has Congress made a clear enough statement? So first of all, consider the overall statutory scheme. Does the overall statutory scheme, do its elements really, cover? Do they on their face appear to cover what the agency is trying to do? The answer in West Virginia is no. If you look at the overall statutory scheme of the Clean Air Act, there are a lot of particularized programs focused inside the fence. And instead, what you have is a massive shift in how power is generated in the country. There's a mismatch between the overall statutory scheme and the statute. Age and focus of the statute. Would we have anticipated the Clean Air Act when it was adopted in the early 1970s to address generation shifting as a result of new views on climate change? No. Prior agency interpretations of the statute. Is this a long time approach that the agency has adopted and built on and it's been accepted. No, this is brand new. The CPP is a brand new approach to interpreting the Clean Air Act and what it's supposed to achieve. And finally, is there a mismatch between the agency's challenged action and its mission and expertise? And this is something both of the main opinions addressed. Is EPA an agency with expertise in deciding how power ought to be generated to meet the many goals that power generation has to satisfy? And the court said no. So if those, perhaps any of them, certainly multiple of them, if those apply, then Congress is not making a clear statement that the regulation is permitted, quite the contrary. And the regulation will be struck down. Okay, Abby, move on. So I've got two slides here, one quote from the concurrence and one from the dissent that I think capture the doctrinal differences that drove the decision and the very different view of the dissenters here about agency authority and congressional authority. So if we didn't have this new doctrine, according to Justices Gorsuch and Alito, legislation would risk becoming nothing more than the will of the current president, or worse yet, the will of the unelected officials, the agency officials, who are barely responsive to him. And we know they're barely responsive to the president because there's no way that a president can control the actions of tens of thousands of folks working in the agency and generating these rules. So in a world like that, agencies could churn out new laws more or less on whim. Intrusions on liberty would not be difficult or rare, but easy and profuse. Stability would be lost, with vast numbers of laws changing with every new presidential administration. If the agencies can adopt new, broad social and economic policies, then with every change in administration, you'll get a different one. And we've seen that with the switch from Obama to Trump and from Trump to Biden. We've seen massive changes in the core direction of the agency's view of what the statutory authority is and what the statutes are supposed to achieve. Rather than embody a wide social consensus and input from minority voices, which is assured in the congressional scheme, laws would more often bear the support only of the party currently in power. So, so the majority are concerned about agencies run amok and about the loss of stability when agencies reflect the views of the administration that they operate under and the changes there. Next slide, Abby. An incredibly different view of the world from three dissenters and writing that's very typical of Justice Kagan. The majority's decision rests on one claim alone, that generation shifting is too new and too big a deal for Congress to have authorized it in Section 111, but that is wrong. A key reason Congress makes broad delegations is so an agency can respond appropriately, commensurately to new and big problems. That's the whole purpose, she thinks. What Congress did not know when it drafted the statute is what the agency is supposed to fill in, and it can fill those in using its expertise, even when the issue is a significant one when they arise. So in the minority's view, the agencies are here in the CPP were doing exactly what they're supposed to do, which is taking an old statute and conforming it to the big issues of the day. Well, for now, we know who's won out, the six more conservative justices. We also know from the history of the Supreme Court that that over time, the composition of the court changes and its ideas change. I had attended an interesting symposium of the law clerks from Justice Brennan, who I clerked for, that it was 3 or 4 years ago, and the symposium addressed what is left of Justice Brennan's legacy after more than a decade of conservative dominance on the court. And the conclusion was very, very little, very, very little 20 years after the justice left the bench. And so, these changes occur as a result of changes in the Supreme Court. And for the moment, we know where we are, but we don't know how long we'll be there. Next slide. So do you want to take this, Avi?
Sure. I think we can both sort of, at this point, trade off thoughts, and we may have some different views. So as we've both mentioned, the major questions doctrine really opens a completely new way to challenge regulations and congressional delegations of regulatory power. There's a line in Justice Kagan's dissent where she says that this new mode of analysis replaces traditional text in context statutory interpretation. And she goes on to say that Justice Kagan had famously said in a previous decision that we are all textualists now, basically acknowledging that over the last 25 years or so, spearheaded by justices like Scalia, the focus of statutory interpretation starts and ends with the text. And in the view of the dissenters, that's no longer the case. And I think the biggest implication coming from this is that this new test is quite judge empowered. When you have to interpret a statute within the bounds of text in the context of the other provisions in a statute, the guardrails are fairly clear, and there are a set number of moves that you can make to advance an interpretation of a statute. But under the majority's clear statement requirement for extraordinary cases, it's not completely clear what will win out. And it may be a bit more in the eye of the beholder. Chief Justice Roberts looked at whether this was an area of traditional EPA competence and prior EPA interpretations, but I think critics would say that that is not how traditional statutory interpretation has worked. You don't look at whether an agency has traditionally regulated in an area. You start with what the text says, and it is not clear under his test what Congress needs to do to make a broad delegation of authority to an agency, because Justice Roberts doesn't say what Congress can do to make their broad delegation clear enough. So I think the biggest takeaway is that it opens this new front and potential challenges, and you're going to see a lot of different sorts of decisions coming from judges depending on whether they think that a statement has been clear enough. We have some clues. I mean,
let me just add that one thing it's worth remembering here is the Supreme Court only takes 60 cases a year. They can't fix every problem in the lower courts. The lower courts are still much more liberal than the Supreme Court, and aren't always willing to buy into the Supreme Court's latest precedents. And these terms, extraordinary, unprecedented, extravagant, radical, vast, sweeping, it's pretty easy to say, well, those are truly, truly extraordinary cases, and have the lower court say, no, we're not going to apply that. That this may be a stretch of the agency's claim of the agency's authority under the statute, but it doesn't meet this extravagant level that it has to for the major questions doctrine to be to be triggered. And they may also find clear authorization in cases where we don't really think there is any, and the court might think there is any. But Supreme Court is not a court of error correction, and the vast majority of decisions by the lower courts will not get Supreme Court review. And so that that raises questions for those considering challenges based on the major questions doctrine, and it's certainly going to make a very important which court you start off in, whether it's one that's more likely to adopt or less likely to adopt major questions. Can you move on, Abby? So it's worth talking about some of the everyone is out there thinking about how can we use this doctrine to improve our law. And it is worth remembering, is that the major questions, clear statement issues don't always play out in favor of business. If you look at the Whitman case, for example, EPA wanted to consider implementation costs of the NAAQS, and the court held no, it didn't have any authority to consider implementation costs because of a lack of a clear statement from Congress. So, it doesn't always come out the way that business would want. The next, potential case in which the issue may arise is the Sackett case to be argued on the first day of term, which concerns the scope of federal jurisdiction under the Clean Water Act under the Waters of the United States rule. CWA defines jurisdictional waters as navigable waters, which are defined as the waters of the United States. And for anyone been following this at all, you will know that it's a complete and utter mess and has been for 30 years. It's one in which the courts already applied clear statements rules that I mentioned before. But I argued in an amicus brief in that case that that the major questions doctrine should apply, that basically an effort by the agencies to convert waters of the United States into a nationwide zoning and land use rule was too big a power grab that lacked a clear statement. And if there had been a clear statement, it would violate the non-delegation doctrine. So that's one. I'll just touch on these briefly. Avi?
Yeah, just very briefly, there have already been rumblings about the implications this could have for the SEC's proposed rule to require certain advisors to give more information in annual reports and prospectuses about their ESG strategies. And you can sort of see an argument here that this diverges from the SEC's historical practice of requiring disclosures on matters which are in SEC's traditional competence, which is whether the investment is going to have a material impact on the average investor. And these ESG disclosures arguably are outside of that. And in addition, Congress has proposed legislation in the past to grant the SEC authority to do things like this, and it hasn't done so. And that's something that the court in West Virginia looked at with respect to the Clean Power Plan. There are others as well. There are similar arguments with respect to the DACA program, that the Immigration and Naturalization Act doesn't give the president the power to do what it did in the DACA program, and Congress has repeatedly failed to enact that power. And there are a few others we mentioned here, but I think one that is particularly interesting is executive orders, which there are dozens of executive orders that require agencies to consider various things when they're making rules, whether it is environmental justice or consultation with tribes, or even things like federalism or competition. Presidents Clinton, Bush, and Obama issued many executive orders, and things like those sorts of things aren't necessarily in the traditional competence of an agency like EPA, whether it's environmental justice or the impacts of its decisions on tribes. So you could see challenges to executive order requirements as well. There are some hurdles, procedural hurdles to challenges like that, certainly. but it's just another area where there is a disconnect, one could argue, between what the agency traditionally does, the statutes that it rely on ask them, what Congress asks them to do in those statutes, and then what the president is telling them to consider in an executive order.
Okay, I think we're at the end of our time here. So with no questions, thank you all for joining us. We appreciate you taking the time to do that. And we'll see you on the next webinar. Thank you.